Your Lordship, I'd like to make mention in respect of item number 15. On behalf of my senior, Mr. Malhotra, he has a fixed item in courtroom number 2, so if this matter may come up after 2 weeks.
No, no objection.
Right.
May I please your lordship?
Motion, item 1.
May I please your lordship? May I please your lordship?
Yes.
I would like to mention item number 13 of the daily list, my lord. I am praying for an adjournment, my lordship, in this matter. I have taken the consent from the other side, my lordship. My lordship may kindly be pleased to fix the matter on next Friday.
Bail application.
My lord, my lord, my lord.
Your good name?
Dayan Hussain, my lord.
As prayed for Mr. Dayan Hussain, learned counsel for the applicants, and not objected to by the other side. List the matter on Friday next.
Highly obliged, my lordship. I am grateful.
Please give the date, okay? Today is what? Today is 13th. Oh. You'll have it on. You want it on 23rd.
My lord.
23rd.
On Friday, next Friday, my lord.
Yes, 23rd.
All right.
All right.
Highly obliged, my lordship. I am grateful.
Motion, item 1.
May I please, Lordship?
Yes.
My Lord, as per last order dated 14/2/2025, this court allowed to file the additional affidavit, my Lord. So accordingly, I filed the additional affidavit on 25th April 2025, my Lord. My Lord, this matter notice has not yet issued, my Lord. Notice may be issued, Lordship.
What is your claim?
My claim is, Lordship, compensation, Lordship. This matter is pertaining to the construction of road linking Nagreswara village to Udaltana village, Lordship. Lordship,
This is a second round.
third round, Lordship.
Okay. Where's the first case?
First case, Lordship, 3rd January, Lordship.
Have you annexed the order?
Sorry, 3rd December 2024, Lordship.
Where's the order passed?
Order passed by the Honorable Suman Siam, Lordship. Sorry, SK Mehdi, Lordship.
No, you don't have to tell the name. You just tell me on which case, which date, what is the case number, what is the order passed?
Case number, Lordship, WPC 132/2024, Lordship.
Have you annexed it? Have you annexed the order?
Order, no, Lordship. I didn't annex, Lordship. But I have
Why didn't you
mentioned,
annex that order? See, have you understood the question I'm putting to you?
Lordship.
You say that this is the third round.
Lordship.
Earlier, you had come to the court on 2 occasions.
2 occasions, Lordship.
What is the order passed?
Lordship,
Is
first order was passed
Is
for
it not?
filing of the additional affidavit, Lordship. That is on dated 3/12/2024, Lordship.
Absolutely, you have not got the question which I've posed before you.
My Lord,
I'm not talking about this case. I'm talking about the earlier case.
earlier case, Lordship.
Did
Yes,
you
Lordship.
did you approach the court? Has the petitioner approached this court earlier by filing
No,
different
Lordship.
writ petitions?
I'm sorry, Lordship. No, Lordship.
That's what I'm asking
Representation
you.
is-
See, when I talk, you just wait for a moment. Don't reply me instantly. You are on VC. So both of us do the talking at the same time. We cannot understand what we're talking to each other about. My specific question was, did the petitioner come before this court by filing writ petitions on earlier occasion? You say on 2 occasions they've come. This is the third round. But now I have understood that what you have understood from my question is that whether this matter was listed earlier or not. It was listed earlier, isn't it?
Lordship.
You were required to file an affidavit. You have filed that affidavit.
Lordship.
See, if you come to the synopsis, you have mentioned one writ petition 62 of 2021.
My lord.
Who are the petitioners there?
Lordship, that one is in page number, annexure 8, Lordship, page number 47, Lordship.
It's okay. Heard Mr. So-and-so Changma, learned counsel for the petitioner, issue notice, returnable by 4 weeks. Ms. Zairam Sankwi, learned CGC, accept notice on behalf of respondent numbers. 1. Who are the others?
Lordship, I have served the copies also to them, Lordship. No formal notice is required, my lord.
You are appearing for whom? Number? You don't have a copy of the writ petition. Then tell me. 2 and 3. Ms. Lalun, who learned government advocate, accepts notice on behalf of respondent numbers 2 and 3. What about video? Chongte. 2, 3, and 4.
16.
As such, no formal notice is required. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing today, if not already done. List the matter again after 4 weeks.
Humbly obliged, Lordship.
Next.
Item 2.
Not possible. 16 is not possible.
My lord.
Lordship, I'm appearing on behalf of the respondent.
Then, my lord, on,
That item
next
number
coming
13.
Thursday, my lord. Coming
I'm
Thursday
appearing
possible, my lord.
on behalf of respondent,
In
Lordship.
which case?
Anytime, it depends upon the. Yeah.
You want it on Thursday?
Thursday, my lord.
Okay, make it, what do you call it? Make it 22nd instead of 23rd. Please write one more line also. Mr. Joniel Tochong, learned special PP,
Special PP, Lordship.
appears for
yes.
the respondent. Okay.
Highly obliged, my lord.
Then appears for the petitioner when the matter is spoken. Hence, for ends of justice, list again after 2 weeks.
Orders, item 12.
No, cancel that order. Just a minute. This is what? From jail?
Yes.
Please write down. This is an appeal from jail filed by the accused oblique convict against the conviction and sentences handed out to him. Stop. Although the Special Superintendent Central Jail Aizawl has forwarded the appeal by stating that the appeal is directed against the SC number 15 of 2018, corresponding to criminal trial number 1906 of 2018. Comma, it is seen that the appellant has been convicted in 3 different cases, which are as follows. Number 1, SC number 151 of 2018, corresponding to criminal trial number 1906 of 2018. In which he was convicted under Section 10 of the POCSO Act and sentenced to undergo rigorous imprisonment for 7 years and to pay fine of rupees 10,000 with a default clause. Number 2, SC number 154 of 2018, corresponding to criminal trial number 1909 of 2018, in which he was convicted by judgment and order dated 29/11/2024 under Section 10 of the POCSO Act and sentenced to undergo rigorous imprisonment for a period of 5 years and pay fine of rupees 10,000 with a default clause. Void order dated 2/12/2024. The previous one, give the order date also, same thing. Void order dated 2/12/2024. Okay, continue. And you may write and. Number 3. Sessions case number 37 of 2019, corresponding to criminal trial number 339 of 2019. By which he was convicted by judgment and order dated 29/1/2025. Under Section 10 of the POCSO Act, and he was sentenced to undergo 5 years rigorous imprisonment and to pay fine of rupees 10,000 with a default clause. Void order dated 4/2/2025. Next para, be it stated herein that all the sentences have been directed to run concurrently. Next para, let notice be issued to the state who will appear. Ms. Lalundui. You are also the PP?
No, Your Lordship. And we have not got a copy of the petition, Your Lordship.
Obviously, you'll not get a copy because it's from jail.
Yes, Your Lordship.
We don't have a PP today in the court,
Your Lordship, they're on legs in the other courtroom.
both of them.
Yes, Your Lordship. Linda and P. Mary.
Ms. Linda L. Fumble, learned public prosecutor, access notice on behalf of the state. Registry to furnish the requisite papers to the learned PP within 2 days. Next para, let notice be issued to the informant. To the officer in charge of the police station concerned. A copy of the notice to be served upon the informant be furnished to the learned public prosecutor, who shall do the needful. The officer in charge of the police station concerned shall report back about service of notice to the learned public prosecutor. Next para, registry to also requisition the LCR in the meantime. List again after 2 weeks.
Orders item 12.
May it please Your Lordship, the pleadings are complete in this case, and if the matter may be listed for hearing, Your Lordship. In a matter of 2 weeks, Your Lordship.
Yes.
Yes.
Yes, Lordship. I have received the affidavit in opposition from the state respondent. Lordship.
Parties are represented by the respective councils and they submit that the matter may be listed for admission hearing after 2 weeks.
Lordship.
Registry to list accordingly.
So,
Admission item 3.
My Lord, I'm here on behalf of Miss Mary. She's on legs in another court, but I have instructions that agenda papers for absorption has been sent to DP and AR. The absorption paper, the agenda papers for absorption has been sent to the DP and AR on the 20th for 2025.
Absorption of whom? What to be
Oh, my
absorbed?
Lord, DRDA employees.
So they were in two parts. One is for Group D, one is Group A employees. Group D, in fact, the DPC was conducted, but Group A, the matter was sent to the MPSC. So you were supposed to get the instruction when the matter was sent to the MPSC. Who's the respondent?
RD Department, Rural Development
Who's the
Department.
respondent? It should be by name. This is a contempt, isn't it?
Yes, my lord.
You tell me the name.
Respondent number 2 is the secretary, Mr. Zardo Sanga.
You are representing whom?
My Lord, I'm here on behalf of Miss Mary and
Yes, and Miss Mary is on behalf of whom?
All the respondents, my lord, is appearing for all the respondents.
Zarzo Sangha is still the secretary.
Yes, my lord. And the respondent number 3, secretary of DPNAR, has recently filed one affidavit.
Yes, what does it say in the affidavit? What do they
In the
say?
affidavit, my lord, they have given the status that post was created for their absorption, and the same was approved by the Council of Ministers meeting. And at present, my lord, so far as my information I received, the Group C and D they have already conducted DPC interview recently for
That we
Group C
know.
and D. And as for the Group A and B, the instruction they have received is that they have sent to the MPSC
That was
by letter
submitted.
dated 28/4.
Oh, that was submitted to the court last date. We know about that already. And Ms. Linda was supposed to tell us when the file was sent. That much only. So if you are aware about the sending of the files, then what to do? We wait for some time.
Yes, my lord, we can wait for some time, but if we can have fixed date.
After 2 weeks.
Yes, my lord, with a fixed date.
As paid for by the parties, list the matter again on
30th.
30th May,
Yes, my lord.
30 May 2025. Learned counsel for the respondent shall inform the court about the up-to-date status in respect of compliance of this code. Court's order. Yes.
Item 4.
Yes.
My lord, the present matter pertains to promotion of the health workers to the post of health supervisor, my lord, by way of limited departmental exam.
So who's for the other side?
In this case, my lord, I'm appealing for the private respondents. I have already filed my affidavit. And the MPSC has also recently filed their affidavit. But as for the state respondents, my lord, they are yet to file their affidavit since the petitioner had filed recast writ petition.
Yes. You are appearing? What is your submission?
This matter was handled by P. Mary, who is on legs in the other courtroom.
Mr. Benjamin appeared last time. He's sitting right behind you. Mr. Benjamin, you are not appearing in this case?
My lord, I have some personal difficulties, my lord. I have resigned from the.
No, no. My question was, are you appearing in this case? Are you handling this case?
No more, my lord.
No more.
No more, my lord.
Since when?
3 weeks back, my lord.
Can't be. I'll read out. Please read. You have the last court's order on 1st of May. 1st of May, it was recorded that Mr. Benjamin Lathamona, learned government advocate, who is appearing for the state respondents, is said to have some personal difficulties on medical grounds, and therefore adjournment has been sought on his behalf
My lord.
by Ms. Lal Nunlui, standing next to you, learned government advocate.
My lord.
Today you say that Ms. Mary is there. Tomorrow Ms. Mary will say Linda is there. What is happening?
My lord, actually, I have some medical issues, so therefore I have resigned from the government, my lord.
You have resigned.
My lord.
Okay. So, you say that I'm no more handling the matter. So now what will happen? Ms. Mary will handle it.
Yes, Your Lordship. And if,
Should I record that?
yes, Your Lordship, P. Mary is handling the case, Your Lordship, it has been endorsed to her, Your Lordship. So if the state has not yet filed the affidavit, so if the court may grant 3 weeks' time, Your Lordship, to file the affidavit.
But you should seek time with responsibility.
Understood,
You're
Your
not even
Lordship.
appearing in the case. You are seeking time for somebody else, and that somebody else might not know that you're seeking time for her. And who's going to communicate to the department that time was sought? We have only 3 weeks' time. You have to organize yourselves. Let Miss Mary come. We'll pass the order in our presence. Passed over for the time being.
Item 5.
May it please, Your Lordship, in terms of the order dated 23/2025 of this order of this petition, Your Lordship, the matter cannot be listed before this bench, before this court, Your Lordship.
Yes, please come here. Bench assistant. What is happening here? Not before me.
Thank you, Your Lordship.
Item 6.
Just leave it there. Leave it there. Leave it there. Whenever he comes, let him come.
May I
Whoever
please,
it
Your Lordship? My Lord, since I have been evicted from the establishment, I would like to withdraw my instant appeal with liberty, my Lord. My only recourse is that now to approach the lower court with amendment. I've been evicted from the drug canteen at Civil Hospital, Bunglei, my Lord. So this appeal is for state.
Please write down. Mr. Lalbia Nunga Namte, Learned Counsel for the appellant, submits that he has instructions to withdraw the appeal. To stop, he further submits that he may be given liberty to approach the appropriate forum with his grievance. Prayers allowed. The appeal stands dismissed as withdrawn. However, liberty is granted to the appellant to approach the appropriate forum as may be permissible in law.
Oblige, my Lord.
Item 7.
Yes.
May please, Lordship. My Lord, this is a MAC appeal
Yes.
under 173 MV Act, my Lord.
Yes.
My Lord, steps was taken upon the respondent number 1 and 2 by filing Talabana, my Lord. So, my lord, ID card has not returned till yet.
When was it taken? Steps, when did you take steps?
My lord, I believe it was 7/2/2025, February.
7/2,
My lord,
2, 3, 4, 5.
7/2.
It's already 3 months now.
My lord, so my lord, I may be allowed to take steps by way of dusty service, my lord. And my lord, in the meanwhile, this respondent number 2, this is the truck owner. My lord, this respondent number 2 is not contesting in the lower court in the tribunal, my lord. So I believe, my lord, this respondent number 2 can be struck off, my lord.
What have you challenged in your appeal? Is it regarding the quantum or your liability?
Liability, whole liability, my lord.
If it's your liability, why should we strike him off?
It's not contesting in the lower court, my lord.
That's a different thing. If it's basically the quantum, okay, not required.
My lord.
Court may look into the quantum, whether it's reasonable or not. But if you're saying the very liability to pay compensation is challenged, then if you are not responsible, then who will pay? Owner will have to pay. How do we strike him off? Understand?
My lord.
Suppose court finds, okay, you're not liable. Insurance company will not pay because there is a violation of the policy.
My lord.
They will not pay. But the claimant cannot remain like that. He will have to be paid compensation. Who will pay the compensation?
My lord.
The owner will have to pay. So we cannot strike him off like that. What do you want to do then?
My lord, I may be allowed to take another steps by way of Talabana, my lord, because this owner is residing in Rajasthan, my lord. This respondent number 2.
What vehicle is that?
This is a truck, my lord.
Truck.
My lord.
You are the insurance company, isn't it?
My lord.
Can you not make some newspaper publication or serve notice by Dasti? Insurance companies everywhere throughout India, isn't it?
My lord.
So you have your resources. What do you want to do? Tell me.
Or maybe, my lord, I may be allowed to accept by a newspaper publication, my lord, in respect of number 2.
One you will take by Dasti.
Dusty, my lord, this is within Aizawl city, my lord.
Okay, please write. All those steps was taken for service of notice upon respondent numbers 1 and 2. Neither AD card nor unserved notice has come back. Stop. Under this circumstance, the learned counsel, Mr. Benjamin Latlamona, submits that he may be allowed to take steps for serving notice by way of Dasti upon respondent number 1. And insofar as respondent number 2, he prays that he may be allowed to serve notice in a substituted manner by newspaper publication. Next para, the prayer of the learned counsel is allowed.
My lord, one more thing. The impugned judgment and order dated 24/1/2022.
Please wait for a minute. I have not completed my dictation. Learned counsel for the appellant shall serve notice to respondent number 1 by way of Dasti through the registry of this court within 10 days from today, and thereafter submit an affidavit as proof of service. Stop. In respect of respondent number 2, the appellant shall cause newspaper publication in a national daily newspaper which is widely circulated, where the respondent number 2 resides, for 2 consecutive days within a period of 3 weeks from today, showing the next court date as 9th of June 2025. No, that will be too early. 23rd of June 2025. Stop. Once newspaper publication is done, the appellant should file an affidavit incorporating the newspaper as proof of newspaper publication. Stop. Yes, what were you saying?
My lord, In the meanwhile, the impugned judgment and order dated 24/1/2024 in MSCT case number 16 of 2020, along with the corrigendum dated 11/6/2024, may be stayed, my lord, during the pendency of the
Why?
appeal, my lord.
How do you stay the judgment? You have not even submitted what is the merits of the appeal. Automatically will stay or tell us, why should we stay?
My lord. My lord,
Yes.
the reason being, my lord, since the tribunal, my lord, has illegally awarded the compensation amount, my lord, and if I may kindly take your lordship to page number before the synopsis, my lord. This is the corrigendum, and the page number is not indicated, my lord. Para number 14 of the award, my lord.
Where? Which page?
My lord, this is the judgment and order dated 24
How do you file appeal
A to N.
petitions without indicating page numbers and all that? You will just compile some papers and just send it to the court like that? Are you not required to follow the rules for drafting?
This is, my lord, para number 14 of the judgment and award, my lord.
At the bottom of the judgment, at the
My
bottom
lord.
of the page which you are holding,
My lord.
are there no page numbers in your copy? Inner page numbers?
Yes, my lord, is
Then-
indicated, my lord.
So why don't you say that it's the inner page number so and so?
This is page number 15, my lord. 14 of the judgment and award, my lord.
I don't think so. You're talking about paragraph 14.
Talking about, yes, my lord, 14.
Paragraph 14 is in the inner page 12.
The pagination, my lord, is not correct, I believe, because in my copy, my lord, it's page 15 of 14, and coming to the next page is 16 of 14, my lord.
So who's responsible for all that? You're the one who has submitted.
My lord.
You will submit a bunch of papers which is different from your copy. And when the matter comes up for hearing, how do you inform the court? That page, this paragraph, it does not tally. Should it not tally?
My lord.
Your copy, my copy, copy for the opposite party, it should all tally. When you say page 14 or paragraph 14, everyone should be able to pinpoint paragraph 14. You cannot say that in my copy it's like that, in your copy it's like that. You should take due care, Mr. Benjamin.
No, my lord.
You're here to get some relief from the court. And if you cannot do things right, then how do you expect to get relief? You want to read paragraph 14?
My lord, paragraph 14.
Yes, read.
My lord. As such, the OP number 2, the new in the assurance.
Just a minute. That is not paragraph 14 here. From where are you reading as such? Okay. Do you have the inner page 12?
Inner page.
Have you got it? Inner page 12.
Yes, my lord.
You just have to turn back 2 pages, that's all, in a page 12. Have you got it? Yes or no?
My lord, I have got the, yes, this is the judgment and award, my lord. This is page 12 or 14, my lord. I've got,
12 or 14?
Yes, my
You've
lord.
got that page, isn't it?
My lord.
Now you see the page, there's also paragraph 14. There are paragraph 14 in 2 places. This is what I'm trying to point out. You should have
Yes,
pointed
my
out to the registry of that tribunal that what kind of certified copy are you issuing. They repeat paragraph numbers.
Yes, my lord, I've got it now.
While taking out the certified copy, don't take out blindly. Please check up. You're the insurance company. This is paragraph 14.
Yes, my lord.
If you turn the next page, it becomes paragraph 12. It's going backwards. Again, if you turn, it's 13. Then again, there's one more 14. 15. It ends on 15. All these things you should check up before filing your appeal. Don't take things for granted. You should see for yourself whether it's there or not. So you want to read paragraph 14 as such. Please read.
Paragraph 14, my lord. As such, the opposite OP number 2, the New India Insurance Company Limited is directed to deposit a sum of 5,77,353 only, along with interest at the rate of 7% per annum from the date of filing, that is 24/8/2020, through NEFT/RTGS in favor of the presiding officer, Motor Resident Claims Tribunals, for onward disbursement of the claimant. The OP number 2, the New India Assurance Company Limited, shall make the deposit within 1 month from the date of judgment of this judgment and order. So, my lord, the interest, this awarded sum, is bearing an interest of 7% per annum. So, my lord.
So what?
So, my lord, the impugned judgment and award may be stayed, my lord, at this point, until the final disposal of the case, my lord.
You mean to say that interest is running, so
My lord.
you want it stayed. But that is not the ground for stay. Judgment can be stayed if you have a prima facie case by which the court is satisfied that you have a prima facie case that you are not liable to pay the compensation. Then we may consider staying it. If you cannot satisfy court in that manner, just because interest is running, why should we stay?
My lord,
That is not the consideration of the court. You must understand.
my lord, the reason being, the amendment to the second schedule was made by notification 22/5/2018, my lord. And as per the amendment to the said second schedule, my lord, the section 164 MV Act 1988 prescribes for this no-fault liability a compensation of maximum 2.5 lakhs, my lord, in case of grievous hurt cases, my lord. So this is the claimants in the lower court, my lord, they have claimed for compensation arising out of the injury sustained by him. So, my lord, as per the amendment to the second schedule by notification dated 22/5/2018, my lord. So this is the reason why we are praying for a stay of the impugned judgment and award, my lord.
Where is the ground to that effect?
This is in grounds number 2. This is page number 8 of my petition, my lord.
Please read.
Point number 2, for the learned tribunal had heard in law and in fact in awarding a sum of 5,77,353 only, along with interest at the rate of 7% per annum from the date of filing, that is 24/8/2020, to the respondent number 1 of the claimant. In this regard, it is submitted that there is no basis for the learned tribunal to award the said amount with interest to the respondent number 1 of the claimant. The amendment to the second schedule was made by notification dated 22/5/2018. As per the said amendment to the second schedule, Section 164 MV Act 1998 prescribes no fault liability compensation of rupees 2,50,000 in grievous heart cases. Accordingly, since the respondent number 1 in the instant case claimed compensation under Section 164 MV Act
Okay,
1988, my lord.
What is 164? What is 164? Give me MV Act. And do you have the notification also? Yes or no?
My lord, I did not bring the notification today, my lord.
You are referring to some notification.
My lord, this is notification dated 22/5/2018.
When you refer that to the grounds, why don't you annex that in your appeal? Are you presuming that everybody knows about this notification, so not required to annex anywhere? Section
This is 164 MV Act, my lord.
164. What is 164? What does it say?
My lord, excuse me, I'm having some heart problem, my lord. So, basically says, my lord, in case of, it prescribes for no fault liability compensation of 2.5 lakhs, my lord,
164.
in 164 MV Act.
Section
my lord.
164.
This is the amendment, my lord.
Where is the 164? 164 says power of central government to make rules.
That is the, my lord, the previous, there is a amendment, my lord.
Of 164?
My lord,
Where's the amendment? When was it amended?
my lord, I did not bring the notification today, my lord.
Bring the notification, we'll see. When
My
will you
lord.
bring? When will you bring?
My lord, maybe tomorrow or day after tomorrow, my lord.
Tomorrow?
Anytime, my lord.
Okay. Uh, I've given you that dictation, isn't it? The entire thing. You please, what do you call it? Type it out. Give it separately. Now you write one small order. List this matter again tomorrow, as paid for by Mr. Benjamin Lathamano, Learned Counsel for the appellate. This will be the order, and the other will be a draft. Okay.
Obliged.
Yes. Anyone has come from the registry? Who? Yes. This is from inside. Yes, please come.
Item 8.
My lord, in this case, LCR may be called, my lord, and paper book also may be prepared, my lord, if it's possible. That's true, my lord. My lord, my lord, yes, only one respondent.
Only one. Yes, my lord. Yes, my lord.
Deeply obliged.
Item number 9.
May I please your lordship? In this case, my lord, the state, they have already filed their affidavit, and they have made only in 2 paragraphs in the counter affidavit. Nothing much is written in the affidavit. It's and this matter can be taken up for disposal, my lord.
Yes, Your Lordship. I do not object.
My lord, the petitioners herein were middle school teachers, regularized middle school teachers. Earlier they were on contract basis and they were regularized subsequently. And after regularization, my lord, now they're claiming for counting of their contractual service for the purpose of upgradation, which was denied. There is a rules of 2020 subsequently issued by the state respondents, which came into force after they were regularized, but it was applied in their case. The petitioners were 27 in numbers, and they were initially appointed on contract basis middle school teachers during the period between 4/9/2011 and 31/8/2012 on contract basis middle school teachers. And thereafter, my lord, they were regularized by the common order on 1/2/2018. 1/2/2018. Thereafter, they were confirmed on 1/2/2022. 1/2/2022. Here, my lord, out of 27, 26 of them were confirmed on 1/2/2022, and the petitioner number 14 was confirmed on separately 26/5/2022. 14, my lord, petition number 14, 14. 26/5/2022. And in terms of the notification dated 19/7/2013, 19/7/2013, they were entitled counting of their contract services as qualifying service for the purpose of upgradation to senior grade. Senior grade. However, they were denied the same by the impugn order dated 28/9/2022. 28/9/2022. This is the impugn order, page number 61, whereby they were allowed only counting 1/3 of their contract period. And in the impugn order, reference was made to rules of 2020, counting of past service rules, 2020, which came into force on 29/5/2020. And the said scheme, the said rules,
In 7/2013, page number
which one, my lord?
19/7/2013,
Page number 58.
counting of your contract period.
Yes, my lord, page
58.
number 58.
This was done away by the impugn notification.
Yes, my lord. By,
Let us come to page 58 first.
Annexure 7, page number 58.
Yes.
Pursuant to the decision of the Council of Ministers in its meeting held on 13/6/2012, a notification dated such and such, and in exercise of the powers conferred by the provision of Article 309 of the Constitution of India, the Governor of Mizoram is pleased to order that the eligible criteria for pay upgradation of government primary school, middle school, and high school teachers in the senior selection grade shall be as follows with effect from 1/6/2012. Para 1, senior grade, trained 1A, regular confirmed government school teachers, headmaster with 8 years service in the relevant entry grade in teaching profession shall be eligible to enjoy the senior grade. B, for the purpose of counting of 8 years in the entry grade, those service rendered in ad hoc deficit service continued by regularization into government service without any break shall be counted as qualifying service.
This is the one.
This is the one, my lord.
1B.
1B, my lord. Likewise, my lord, for
You belong to senior grade.
we are in the entry grade and we are claiming for senior grade. For the purpose of upgradation to senior grade, 8 years is required from entry, relevant entry. And for that purpose, we are claiming for counting of our contractual period. And in page number 60, there is a corrigendum to this notification, which includes counting of CSS service amongst other, in addition to the other service, which were not concerned with the present case. Now,
Earlier it was ad hoc and deficit.
yes, my lord.
Now they also say that even CSS.
Yes, my lord.
Okay, then?
And in the impugn order, my lord, page number 61.
Yes.
This is office order dated 28 September 2022. In pursuance to the Mizoram government employees counting of past service rules 2020, notified on white such and such, dated 28/5/2020 and published in the official gazette white issue number such and such on 29/5/2020. This is the enforcement date of the rules of 2020. Counting of 1/3 of the past service rendered by the following petitioners, 27 middle school teachers, as contract teachers is hereby allowed to be counted as qualified service for non-functional upgradation to senior grade. I'm reading page number 61. Office order. Office order dated 28 September 2022. Here in the impugn, this is the impugn office order, and they are referring to these rules of 2020. Because, my lord, by referring to these rules of 2020 and by this impugn order, we were allowed to count only 1/3 of our contract period.
In pursuance to the Mizoram government employees counting of past service rules 2020. So this rules only gives for 1/3.
Yes, my lord.
Counting of 1/3 of past service. Consent.
Now, if you allow me to address the rules of 2020, page number 63.
Yes.
Before that, my lord, the earlier notification dated 19/7/2013, which I have referred earlier, was made under Article 309 of the Constitution of India. And this page number 63, have you got it, my lord? Annexure
Yes.
10.
Yes.
This is the rules of government employees counting of past service rules. In exercise of the powers conferred by proviso to Article 309 of the Constitution, the Governor of Mizoram hereby makes the following rules regulating the conditions of service of officials with prior service rendered as work charge, contract, provisional, or any ad hoc officiating employees under the government of Mizoram. These rules may be called the Mizoram government employees counting of past service rules 2020. They shall come into force from the date of publication in the official gazette, that is 29/5/2020. In our case, my lord, we were regularized on 1/1/2018.
Just a minute. Huh? Coming to force on 29/5/2020.
Yes, my lord.
You were regularized on 1/2/18.
1/2/2018.
So,
And page number 65, my lord. Running page number 65. Para 5. Counting of past service as qualifying service for promotion to higher grade, higher post. 1/3 of the past service rendered by a work charge, contract, provisional, or any ad hoc officiating employee as specified under Rule 2 of these rules shall be counted upon regular appointment to the same substantive sanctioned post in the feeder post grade as regular service for the purpose of determining eligibility for promotion to next higher post, including promotion to LDE unless otherwise expressly provided in the relevant recruitment rules. My humble understanding is that when the contract employees are regularized on the same substantive sanction post, they can count 1/3 of their past service contractual period.
so this is the clause only which provides for 1/3.
Yes, my lord. Yes, my lord. And thereafter, my lord, one impugn of his memorandum was again issued by the state respondents, which is in page number 71.
But before that, you see, okay, this one comes into force with effect from publication in the Gazette.
Yes, my lord.
That is 29/5/2020.
Yes, my lord. Thereafter, they are making this retrospective effect. They have given this retrospective effect. Page number 71.
71.
This is the impugned office memorandum,
71.
page number 71.
So what is your case?
My
That
lord-
they cannot make the retrospective effect by way of an executive instruction.
Besides that, my lord, this impugned OM, which I'm yet to address, this is an executive instruction amending the rules of 2020, which was made under the.
That's exactly what I'm saying.
Yes, my lord.
That is what you're getting at.
Yes, my lord.
Okay, 2020 rules came out, but it came to be effective from the date of publication.
Yes, my lord.
Your case is that you were regularized in 2018.
Yes, my lord.
So that rule doesn't cover you.
Yes, my lord.
Now to make you also be covered by that rules, they have made one office memorandum,
Yes, my lord. Correct.
like executive instruction,
Yes,
saying that this will apply from which date?
My lord, this office memorandum, 22nd January 2021. The subject was made as clarification on implementation of the rules of 2020. Although they have given clarification, my lord, it amounts to amendment. If I
Well,
may,
Take me to the provision straight away.
yes, my lord. Para 2.1, Para 2.1.
2:1.
The application to these rules covers all employees with prior service rendered as specified under Rule 2 of the Rules of 2020, irrespective of their date of regularization, whether before or after the said rule came into force. And
Rule 2 of what? Rule 2.
rules,
What is Rule 2?
the applicable, page number 63, which says that these rules shall be applicable to those employees who have prior service on either contract or.
Okay,
or charge.
understood. So irrespective of whether you were regularized before or not, these rules will apply to you.
Yes, my lord.
This is your grievance.
And one more, my lord. Para 2, this same page 71.
Yes.
Para 2, Roman 3, A and B. The determination of effective date for benefits under the rules of 2020. Each employee may differ on a case-to-case basis. In case of an employee not yet confirmed on the date these rules came into force, his eligibility will only be effective from the date he declared as confirmed. B, we are grievance with this. In case of a confirmed employee, his eligibility will be effective from the date of these rules came into force, 29/5/2020. In case of a confirmed employee, his eligibility will be effective from the date of these rules came into force.
So
In
what
our
does it
case, my
mean?
lord, we were regularized on 2022. In spite of the fact that our regularization order provided that the period of probation will be only 2 years. That is supposed to be completed by February 2020. But unfortunately, we were confirmed belatedly by giving effective from 2022. Be that as it may, my lord, under any circumstances, this impugned office memorandum cannot stand the test of law.
In case of a confirmed employee, his eligibility will be effective from the date of these rules. So you'll be able to count only from 29/5/2020.
In fact, my lord, we are under A. In case of an employee not yet confirmed on the date these rules came into force, that is 29/5/2020.
Okay.
We are not yet confirmed by that time.
His eligibility will be effective only from the date of his declared confirmed.
That means
So that means from 22.
22,
From 22, what will he count?
1/3. We are made applicable to under the rules of 2020.
1/3 of your past service.
Yes, my lord.
That means counting from
2011 and 12.
2011
respectively.
and 12 up till
2018.
of course.
The
Up till
period
2018.
of our contractual service.
So how does it work, this clause 2 subsection subclause 3A? Determination of effective date for benefit under these rules. So you'll be able to count your 1/3 only from date of your confirmation.
As per this
Ah.
23A. And also under this 2.1.
2-1 says that whether you are appointed before, regularized on a particular date or not. The counting of past service rules of 2020 will apply to you. Yes. Now, what is the stand of the respondents?
The stand of the state respondents is that since we were regularized after commencement of the rules of 2020, we cannot enjoy the benefits of counting the entire service.
No, you regularized in 2018.
Yes, my lord.
you
Before
said
that, my
out-
lord,
huh?
if I may take a lordship to one impugned letter, page number 69, of my writ petition, Annex 11. This is in reply to the representation submitted by one of the petitioner
Please read.
to Mr. V. Lalthamwan. He is the petitioner number 1, the president, 2011 and 12 middle school teachers. Subject, proposal for counting of past service in full period regarding. The representation for counting of past service in full has been carefully examined and concluded to uphold the earlier decision conveyed by ID number census dated 15/9/2022. This due to the fact that the proposal was received after the effective date of the Mizoram Government Employees Counting of Past Service Rules 2020, which stipulates that only 1/3 of past service rendered as contract can be counted upon regularization. My humble understanding is that since they have received the representation and claim of the petitioners after these rules came into force, they were denied the same. Yes, ma'am. May I please your lordship? I would like to take your lordship to page number 73 of my writ petition. Yes, my lord. They have rejected the representation of the petitioner by stating that the same was received after the rules of 2020 came into force, which stipulates only 1/3 of their past service can be counted. Unfortunately, my lord, the petitioner have not retained a copy of their representation, but it can be presumed that the rejection was issued on 2/8/2023, and 59 is the enclosure of the letter dated 2/8/2023, whereby the DPNAR had considered and rejected the claim of the petitioners in line with, by advising to consider the case under the rules of 2020.
I mean that it also includes the OM also. The
No, my lord.
subsequent
No, my lord.
clarification.
They were referring only the main principal rules.
So
2020.
if it's only the main principal rules, then it doesn't debar you, isn't it?
Yes, my lord.
Because it is effective only from a particular date.
Yes, my lord.
And it's not clear whether it should go back in time and cover your case.
Yes, my lord.
Then this clarification came
Yes, my lord.
in 21.
Yes, my lord. But it rather amounts to amendment instead of clarification.
But this 21 clarification, perhaps what they want to say is that since it's only clarification, that means 21 and 2020 will have to be read together. If it's read together, you're debarred. And as per the DPNR's clarification, they say that it should be read with in line with the 2020 rules. So what I meant to say was that it means that 2020 rules means it includes that clarification also. That is what they meant. Otherwise, in your stand, it would be that it does not cover me because of the effective date. Yes, you were referring to some page,
Yes, my
73.
lord. 73.
What is this?
This is Annexure 14. Annexure 14, 15, and 16, they were the upgradation order of similarly situated other teachers. This, page number 73, notification dated 3rd August 2018. This is in respect of 75 primary school teachers. In continuation and in pursuant modification of these departments, notification issued under memo number dated 19/7/2013. The following 75 primary school teachers, as shown in Annexure 1, are hereby allowed counting of past service rendered on contract basis for the purpose of non-functional promotion to higher grades on the condition of such and such. And if your lordship may kindly see the following page, the enclosure of the same notification at page number 74.
Yes.
On the second last column, the date of their entry on contract basis is given, and on the last column, the effective date of their regularization. And the page 73, the notification was issued on 3rd August 2018, my lord. So, meaning thereby, my lord, the petitioners, consequent upon regularization on 2018, and upon completion of 8 years, counting from their initial contract appointment, they have already completed 8 years continuous service on 2019 and 14, 2019 and 20 February. And page number 78. This is also another upgradation notification. in
No, I did not get what you were saying. I have not understood what you were saying.
Yes, my lord. Under the notification dated 19/7/2013,
Yes.
either regularization or confirmation. Prior to confirmation, they can be granted the benefit of upgradation by counting of the contractual period under the notification dated 19/7/2013. Likewise, my lord, in this Annexure 14, page 73, those 75 primary school teachers who were allowed counting of their contractual service were also given the same benefit immediately after they completed, they were regularized in 2017, before their confirmation.
Before confirmation.
Yes, my lord. The 19/7/2013 only requires either regularization or confirmation. Confirmation is not mandatory. But under the rules of 2020,
No, how do you say either regularization or confirmation?
19/7/2013, page number 58.
Does it say like that?
Yes, my lord. Page number 58, Annexure 7, Para 1A, regular or confirmed. Even before they are confirmed, once they are regularized, they can enjoy the state benefits.
You said you're covered by B, 1B.
That is correct, my lord. But for the purpose of this, when can they avail these benefits? After regularized or confirmed. So in this page number 73, these primary school teachers were also regularized on 9/11/2017. And the upgradation order was issued on August 2018.
So this 2013 notification is there. Then 2020 notification is also there.
Yes, my lord.
2020 notification does not say that in supersession or
It does
repeal
not say.
saving.
It does not say.
So how is it to be understood? Both of them exist side by side.
Yes, my lord. If I may take a lordship to page number 84 to clarify that point. Page number 84, NS 17. Those who were regularized after commencement of the rules of 2020, my lord, in their regularization order, specific statement was made, like this notification 30th May 2023. They were regularized on this day, and on the second last para, my lord, it was specifically stated that the past service rendered by them shall be counted as per the rules of 2020. Those who were regularized after the commencement of the rules of 2020, this clause, this statement was included in the regularization order itself. At the time of our regularization, these rules of 2020
Where
not
is
in
your
existence.
regularization order?
My regularization order is in page number 49.
Of course, it will not be there because that rules had not been yet framed.
Annexure 3, page number 49.
29
49,
or 49.
office order dated 1st February 2018. Here, serial number 1 to 27 are all the petitioners before this honorable court. And on page number 50,
No, it refers to the Government of Mizoram Regularization of Contract Employee Scheme 2008.
this is in respect of leave. And it also provided,
How do you say that it is in respect of leave? It doesn't say so. Page 49.
50, my lord, 50. The continuation of the same order.
Past service rendered by them as continuous contract employee shall be counted for the purpose of leave only.
This is in terms of the contract regulation amendment scheme 2015. And here it also stated that they shall be on probation for 2 years, which may be extended for good and sufficient reason. But unfortunately, since their confirmation order was belatedly issued on 26/5/2022, they have also submitted representation to prepone the effective date, which is still pending before the respondent authority.
No, your regularization was in 2018, correct?
Yes, my lord.
It says that your past service. No, your regularization has been done in terms of the 2008 scheme.
Yes, my lord. As amended from time to time.
Then what is this 2015?
And this 2015 amended para 7 of the scheme of 2018. Earlier in the scheme of 2008, original scheme, the provision was that their past service can be counted for the purpose of both pensionary benefits and leave.
Okay.
But by way of this 2015 amendment, they have deleted the pensionary benefits, but only leave can be counted
Leave can be counted.
in terms of the scheme of this regularization scheme. And
Okay, now this is separate. Notification 2013 is separate for school education
yes,
department.
my lord. It,
So under
it
this
provides
notification-
upgradation.
Under this notification, you can count your upgradation.
Yes, my
For
lord.
the purpose of upgradation, you can count your past service.
Yes, my lord.
And primary teachers were given this benefit.
Yes, my lord. Here, in
But
Excel
in your
40
case, regularization came in 2018, then confirmation 2022. In the meantime, the (2020) came into being.
This annexure 14, 15, and 16, they were primary school teachers, middle school teachers, and high school teachers respectively, who were granted these benefits by counting their entire contractual period. But these were issued during the year 2018 on August, June, and February. But in our case, as can be seen from the rejection of my representation, since the proposal, when the proposal was received by the concerned department, the rules of 2020 came into force. That is the ground.
Oh, correct. So rules of 2020 came into force, which gives only 1/3. And although you say that it is retrospective, it is not retrospective, but they came up with the office memorandum, making it retrospective. So according to the respondents, 2020 means including the amendment.
Yes, my lord.
That is why they have not referred anything regarding amendment. But that is what they understood. Obviously, because otherwise they would have given him the relief. On the other hand, your case is that you cannot amend like that.
Yes, my lord.
You have given 2020, no doubt. 2020 is there, but it goes prospective. Later on, by way of OM, you cannot come up with another amendment to the rules framed under Article 309. Let us see the reply, the affidavit. What do they say?
Their main stand is that since they were confirmed after the impugned OM, they are referring to Parat 2 subparat 3.
Where?
In the affidavit filed by the state respondents 1 to 5, para 4. It's a small affidavit.
Yes.
If I
Para
may,
4.
if I may read, Your Lordship, that with regard to statements made in para number 10 of the petition, it is pertinent to mention here that the present petitioners were appointed on contract basis during the period between 2011 and 2012 and therefore regularized on 1/2/2018. All the petitioners except petition number 14 was confirmed on 26/5/2022. That the present petitioner's confirmation dates to the post of government middle school teachers under School Education Department mentioned above shows that the confirmation is after promulgation of the Mizoram Government Employees Counting of Past Services Rules 2020 that came into force on 28/5/2020. Thus, they were governed by the said rules. In connection with this, the Government Office Memorandum dated 22/1/2021, para sub number 3 is reproduced here as below. In case of an employee not yet confirmed on the date these rules came into force, his eligibility will only be effective from the date he is declared as confirmed. Since the petitioners have been confirmed only after the Mizoram Government Employees Counting of Past Service Rule 2020 that came into effect on 28/5/2020, they have to be governed by the said rule. Pan number 5, Your Lordship, that with regard to statements made in pan number 11 of the writ petition, I say that clause D of the sub rule 3 of rule 3 of the Mizoram Government Employees Rules 2020 specifically excluded only those contract employees engaged before the commencement of the Government Rules Regularization of Contract Employees Scheme 2008 notification via number so and so dated 10/10/2008. Since the petitioners engaged on contract basis during the period between 2011 and 2012, they are governed by the 2020 rules. That is all, Your Lordship. That is the submission that we have, Your Lordship.
Rule 3, sub rule 3D, what is this?
Your Lordship, this is from Rule 3,
Page 71.
page 71.
71 or 64?
Sixty-four, they mean to say that
64.
it excludes those who were regularized on contract basis before 2008. But the present petitioners were appointed after this.
No, but this provision, what does it say? Page 64?
It says, Your Lordship, if I may read, the candidates were recruited initially on the recommendation of the relevant department promotion committee with the exception of D, contract employees initially engaged before the commencement of the government Mizoram.
No, you have to read from 3.
Yes, sir. Yes, Your Lordship.
Previous page, 63. Work charge contract.
Yes, Your Lordship.
The
Rule number
candidates-
3.
The candidates.
Rule number 3, work charge.
Work charge, contract, provisional, or any ad hoc officiating employees as specified under Rule 2 of these rules shall be eligible for the benefits provided under these rules upon fulfillment of the following conditions. 1. There is no break between the prior service rendered as work charged, contract, provisional, or any ad hoc officiating employees and the regular appointment to the same substantive sanctioned post, provided that technical break resorted to by government in respect of these categories of employees shall not be treated as break for the purpose of this rule. And 2, the candidates fulfilled all the eligibility conditions as prescribed by the recruitment rules in force at the time of initial engagement, or the eligibility conditions as prescribed by the government at the time of initial engagement in case there are no relevant recruitment rules. And 3, the candidates were recruited initially on the recommendation of the relevant department promotion committee with the exception of A, provisional employee initially engaged before the issue of office memorandum number dated so in
Okay, you can stop there.
Yes, Your Lordship.
Straight away you can go to D, contract employees.
Yes, Your Lordship. D, contract employee initially engaged before the commencement of the Government of Mizoram Regularization of Contract Employees Scheme 2008, notified via number so and so dated 10/10/2008, which came into force on 10/10/2008.
So this is an exception. If you are recruited under 2008, then you are exempted. But petitioners herein were recruited in 2011-12. So according to you, they are not covered.
Yes, Your Lordship.
Mr. Victor, have you raised any issue regarding the OM overriding the provisions of 309?
Yes, my lord.
Where is that?
Para 14, page number 17. Para 14, page number 17, and
Okay.
para 20, 20.
20 also.
Yes, my lord.
What is the reply to that?
No reply.
We have not, the state respondents have not
They have nothing to
contested,
say.
Your Lordship.
Paragraph 14,
14 and 20.
14 and 20.
They have made specific averments only in respect of para 1 to 10, but the remaining they have nothing to say.
Okay. And your prayer is for setting aside of which?
My lord, my prayer is in page number 22. I have sought for setting aside of the impugned office order dated 28/9/2022, whereby we were allowed to count only 1/3, as well as the impugned letter dated 2/8/2023, which reject my representation by referring to the ID dated 5/15/2022. And secondly, my lord, yes, my lord. And page number 69, page number 69. As well as page number, yes, my lord. And the subsequent page, 15/9. Yes, my lord. Fifteen 9, NSA 12, page number 70. Page number 70. Page number 70 is the enclosure of page number 69, wherein they have referred the comments, advice of the DPNAR. Twelve and 13. No, my lord. This para 2-1. In spite of the fact that the rules of 2020, the principal rules, provided that it shall come into force from the date of publication in the official gazette, which is 29/5/2020. But this para 2-1, it amends the entire effective date.
Well, counting of past service rules, not meant only for school education department.
Yes, my lord.
It is meant for everyone.
Yes, my lord.
It's a general order.
Yes, my lord.
So if this is interfered with, that means all those persons who are similarly situated in any department will have the same benefit. It is not specific for the petitioners. It is for everybody. So that is the long and short of the case.
Yes, my lord. And I would like to place authority reported in 2011, volume 11, SCC 136. Ajaya Kumar Das versus State of Orissa,
Para,
para 14.
This is regarding?
Regarding the executive order and not override statutory provision, rules made under Article 309. Para 14. It is well settled that the statutory rules framed under Article 309 can be amended only by rule or notification duly made under 309 and not other ways. Whatever be the efficacy of the executive order or circulars or instructions, statutory rules cannot be altered or amended by such executive orders or circulars or instructions, nor can they replace the statutory rules. The rules made under Article 309 of the Constitution cannot be tinkered by the administrative instructions or circular.
Okay. We'll dispose it of.
Yes, Your Lordship.
Please write down, heard Mr. Victor L. Ralte, learned counsel for the petitioners, and Ms. Lalnun Louis, learned government advocate for the respondents. Stop having regard to the projection made by the petitioners and the response made by the respondents. The writ petition is taken up for disposal at the admission stage. Stop next para. The case of the petitioners is that they were appointed as middle school teachers on contract basis between 4/9/2011 to 31/8/2012. So they were regularized in service on 1/2/2018. And thereafter, all except the petition number 14 were confirmed in service on 1/2/2022. Stop the petitioner number 14. On 26/5/2022. According to the petitioners, having continuously served as middle school teachers since their initial appointment, they are eligible to be considered for upward movement in the same grade. Middle school teacher. In terms of notification dated 19/7/2020, bracket section 7. why is that? The regular or confirmed government school teacher for a class time. Adding 8 years of service. Shall be eligible for during the state of care of CNB. As per paragraph 1, bracket B of the same notification for the purpose of counting 8 years of service about the service rendered on the law of the visit. Basis continued by regularization into government service without break in service. Qualified service. Subsequently, by collegial updated. To 7/20/48. The services rendered under CSS would also be counted for computing the 8 years of service. So, however, when the petitioners were regularized by office order dated 28/9/2022.
No, my lord. That is the impugn order. I heard it, the LOCP is saying this is the regularization order.
By office order dated 28/9/2022. The petitioners were allowed to count only 1/5 of their past service. In terms of the provisions of the Mizoram government employees, open bracket, counting of past service, close bracket, rules from 2020. Open bracket, rules of 2020. So the representation submitted by
Vilal Sambona, page number 69.
submitted by the petition number 1. On his behalf and on behalf of other teachers was rejected. But 9/2022. Bracket Minister 12. Of the Indian Act. And it was communicated to petition number 1 on 2/8/2023. Bracket Minister 11. Primary school teachers who were given the benefit of counting their past service for movement to the senior grade of this service. The petitioners are eligible to be given to be allowed to count their past services rendered on contract basis. As per the notification dated 19/7/2013. So in fact, the same notification does not make any distinction between regularization and confirmation. And that either of the two is applicable. So the same can be appreciated from benefit given to the primary school teachers. Primary high school.
My lord, I have annexed 3 documents. They are primary, middle, and high school. This page number 73
Primary.
is in respect of primary. Fourteen is primary, 15 is middle school, and 16 are high school.
Okay, 14, 15, and 16, respectively. So the learned council submits that notification dated 19/7/2013 has been issued inside of the powers conferred by the proviso to Article 309 of the Constitution. Dated 22/1/2021. Making certain clarification on the implementation of the rules of 2020. So, clause 2, bracket, Roman 1 small, of the English memorandum, provided that the application of the rules of 2020 covers all employees with prior services rendered as specified under Rule 2 of the Rules of 2020, irrespective of their date of regularization, whether or before or after the same rules came into force. Clause 2, bracket 4/3, bracket 4A, further provides that the determination of effective date for benefit under the rules of 2020 may differ on case-to-case basis. And in case of employee not yet confirmed on the date the rules came into force, or his eligibility will only be in effect from the date is declared as confirmed. So the other council submits that by applying the rules of 2020 and also the subsequent clarification issue right from dated 22/1/2021. So our respondents have replied the petitioners from counting their past service rendered on contract basis for movement to the same date of the distribution. So we suppose that since the notification dated 19/7/2013, which permits counting of the past service rendered on contract basis without any deduction, currently the exercise of the powers conferred by proviso to Article 3 of the Constitution of India. From Article dated 22/1/2021, which is in the form of executive instruction. Over by embedded notification. That was what is that. The inaction of the disposal should be taken, and the issue should be done around the past. Level of the practices without any reduction. So, with some of the submission, the Merit Council has spent on these Ajaya Kumar Das versus State of Odisha and others. 2011, 136. Stop there, not including government organization. On the other hand, by referring to the petition filed by the respondents, something that all the petitioners except the petitioner of the was confirmed, were confirmed. From 1/2/2022.
Okay.
Petition of voting was confirmed means that except for OD, everyone was confirmed on 26/5. That the except for OD, everyone was confirmed on 1/2/2023.
Yes, my lord. Yes, my lord. It is.
Something wrong with this. What did I say? And the additional voting was confirmed on 26/5/2023. Whereas, the units of 2020 came into force on the day of its publication in the Mizoram Gazette, that is 29/5/2020. The office memorandum identifying the implementation of the rules of 2020 was issued on 22/1/2021. Therefore, the petitions have been confirmed post the notification dated 29/5/2020 and the office memorandum dated 22/1/2021. So now they can count only 1/3 of the service. That's permitted by the rules of 2020. So, something that not to bracket one is small, bracket small a of the office memorandum. Therefore, the petitioners were rightly given some benefit from being 1/3 of the past service, like this order dated 8/9/2022. She also suffers that unlike the petitioners, only those contract authorities were engaged prior to the commencement of the government of Mizoram regularization of contract employees scheme 2008 are exempted. So that's that the petition has globally same business. Next time. Our submission made by the government of there will be materials available. Now, the issue that we decided is as to whether the rules of 2020 and the office memorandum dated 22/1/2021 become their past service, general and contract basis. For upward movement to the senior grade, it was completed. Of the respondents to the notification dated 19/7/2015. Issued in the side of provider of the Article 69 of the Constitution of India and prohibited counting of 3 years of service. Either rendered on ad hoc basis or on deficit basis. Without any break or without any break, and which is continued by regularization. For getting the benefit of senior grade. A. Thereafter, by provision of dated 2/7/2014, employees who have earlier rendered under the CFS aim to be included get such benefit. So you may notice that even the provision that was issued in exercise of the powers conferred by provider of the Article 309 of the Constitution. So the new notification did the rules of 2020 issued by notification dated 29/5/2020. The issue notification, so the issue, the rules of 2020 per se, per se, does not appear to debar the petitioners from counting their past service for movement to the senior grade petitioning. Since the same is made effective on the date of its application in the General Gazette, that was 29/5/2020. past service rendered on account slash dash CSS. Or the British Constitution would be governed by notification dated 1970. So however, with the office memorandum dated 22/1/2021, which provided for the applicability of the rules of 2020 to everyone, irrespective of the date of regularization. And also the necessity of being confirmed in service in order to avail for the benefit of county past service. Our situation has changed. The petitioners therefore have been brought under the ambit of the rules of 2020 and they have been allowed to count only 1/3 of the past. From the date they have been confirmed themselves. However, the fact remains that it is dated 22/1/2021. Application in the form of an executive instruction. And that the law to develop is that the rules made under Article 39 of the Constitution cannot be implemented. By way of an executive order, circular, or instruction. Of the effects to be observed by us. Under the given facts, circumstances of that case. This memorandum dated 22/1/2021 in an executive instruction in exercise of the powers conferred by Article 69 of the Constitution of India. Has not been remarked. This court has also noticed that the respondents have also extended the benefit of the office Dated 19/7/2013. Primary people and high school teachers who are similarly situated and were regularized heading the head of the petitioners. Next paragraph, that's not how the consideration of the materials available on the board. This court finds that the petitioners are also eligible to be granted the benefit of counting their entire past knowledge to move to the same rate, basically, in terms of notification dated 19/7/2013. Having copies of the packet, this order dated 28/5/2020. Is it okay? Insofar as it grants only 1/3 of the past knowledge to the petitioners. For granting, move to the senior public selection grade. Similarly, the communication dated 2/8/2023. 3/9/2023. As well as the office memorandum dated 22/1/2023.
Deeply obliged.
Much obliged, Lordship.
My sincere apologies, my lord. I was on late. Yes. Yes, I have recently
And
got the
you're going to
endorsement.
handle this matter now.
Yes,
So the affidavit has not been filed
yes.
on the amended writ petition, I think. Amended writ petition.
My lord, recast. My lord,
What
yes.
is the amendment?
The
MPSC?
amendment is only with regard to the implement of MPSC.
So are you going to file affidavit to that?
Yes, Your Lordship, I have gone through the file, but I have, my learned friend Benjamin have received in the end of April, the unvetted Paraguay's comment. I believe that even though I haven't taken the instructions, I believe that the matter is sent for vetting at this stage.
Okay, that is okay. What I was saying is that the amendment which has been done, because earlier they have filed affidavit, you have filed affidavit, they have filed affidavit.
my lord.
or not?
Yeah, my lord, it seems
They have not
so
filed.
for us, yes, not filed.
They have not filed.
Not
They
filed.
have filed, they had filed.
You are not agreeing to anything.
In the original writ
Apart
petition,
from fighting in this case, you're not agreeing whether affidavit is filed or not also. You say you don't, he has not filed. He says they filed. They have filed.
yes, my lord,
Now, amendment came later on.
yes, my lord.
And the thing is that whether you're going to file affidavit on the amendment or not. And I asked him, what is the amendment? He says that it's only implementing the MPSC. So what is there to counter in the implement of MPSC?
No, my lord, that is not correct. In the original writ petition, there is only one writ petitioner. And subsequently, another 8 persons were implemented as petitioners.
Okay.
So the entire scenario has changed.
With the increase of the petitioners.
Yes, my lord. Because the original writ petitioner, he has not cast and die.
All right. But you have filed your affidavit, isn't it? Private respondent,
Yes, my lord.
you have filed.
Yes, my lord.
State government has not filed. How much time should you require?
I may be given at least 2 weeks' time.
2 weeks' time. All right, fine. Parties are represented
lord.
by the respective councils. Yes. Anything?
Sorry to interrupt, my lord. I have IA. I have filed one IA.
IA for what?
They,
I'm seeking to stay.
Stay what?
The state government had recently notified 17 posts to be filled up through LDE, the post of health supervisor.
Okay.
And this IA number 73 of 2025, it is listed for the first time today. But unless this honorable court interferes with, my lord, there will be multiplicity of case.
No, but see, you see the manner in which is listed today. The petition has come before IA.
It is listed.
Normally, when the IA is filed in the course of the pendency of the writ petition, then IA is listed. Then WPC in so and so. Then we concentrate on the IA. What is this IA for? For amendment, for deletion of names, or something, whatever. But here it comes separately.
In the main writ petition, my lord, today is the fixed date.
Main is for today's the 6th for today.
Yes, my lord.
That we have understood. But the thing
And
is that
last week I have filed this IA and it came up together.
so we can do one thing. We'll issue notice. Let it come up after a week.
If some, at least, observation or interim order.
No such kind of observation.
Otherwise, my lord, the thing is that the issues herein is that the petitioners were challenging the promotion of the private respondents by way of LDE. And during pendency of this writ petition, my lord, the state respondents have notified.
Just a minute. What did I say just now? What is? Stop. At the outset, Ms. Mary L. Kyangte, learned government advocate, submits that she has been recently endorsed with the brief, and she may be given 2 weeks' time to file counter affidavit to the amended writ petition. Stop. Okay. Now you come to your IA. What have you
Yes,
said
my
in the
lord.
IA?
I have to address to the entire scenario on the merit, my lord, to consider this IA. Earlier, my lord, there is this recruitment rules under the health department in respect of the post of health supervisor and health workers. And in terms of the recruitment rules, my lord, there is no classification of posts for male and female. And in spite of that, the state respondents were making separate seniority lists, and that has been challenged in separate proceeding. And during pendency of that writ petition, my lord, this the notification was issued for filling up of LDE.
Come to page annexure 5. You want stay of this?
Yes, my lord.
What is there? Annexure 5.
This is notification.
They're
dated-
going to conduct exams when?
Not yet scheduled, my lord, but the last date of application was made as 9th of February.
And today is what?
Today is
13.
13th.
So nothing will happen. It's not said here that this is the date for examination. So what I'm suggesting is that we issue notice and we consider this application on after a week, maybe probably on Monday, whether to stay or not.
Let it.
Okay. Next para. At this stage, Mr. Victor L. Ralte, Learned Counsel for the petitioners, submits that. No, sorry, Learned Counsel for the private respondents submits that he has filed an IA, that is IA number 73 of 2025. No, not required. At this stage, from there you cut, okay? As paid for, 2 weeks' time is granted to the state respondents for filing their counter affidavit. That is in WPC. Now you write a separate order in the IA. Heard Mr. Victor L. Ralte, learned counsel for the applicant, stroke private respondents in WPC number 85 of 2023, who submits that by filing this application, he has sought for stay of the notification dated. There's no date? Oh, there's a date. 7/4/2025, bracket annexure 5, by which the Mizoram Public Service Commission is intending to fill up 17 posts of health supervisor by limited departmental examination. To stop, the learned counsel submits that since the writ petition is yet to be decided by this court, if the notification, if the post of health supervisor is filled up by LDE in the meantime, the private respondents would suffer irreparable loss and hardship. Stop. Hence, the instant IA has been filed, seeking suspension of the same. Next para, issue notice returnable by 1 week. Ms. Lalnun Lui, learned government advocate, accepts notice on behalf of the state respondents, while Mr. F. Laliang Liana, learned counsel, accepts notice on behalf of the opposite party, stroke state writ petitioners. Yes, young lady.
My lord, I'm appearing on behalf of my senior, Mr. Jesse, who is the respondent for MPSC, respondent number 53, my lord.
In this IA, you are respondent number?
Number 15, my lord.
15. What's a good name?
Daphne Leshwaitlongi, my lord.
Ms. Daphne Lalwaitlongi, learned counsel, appears on behalf of Mr. J.C. Lanunsang, learned standing counsel, MPSC.
My lord, if I may be allowed to make another small submission, we
Yes.
have also filed our WO in the main matter, my lord.
In the
In the
main
main-
petition, they have filed their affidavit.
Yes, my lord.
That's okay. Affidavit main to have already, just a minute. And
Yes, ma'am.
an accepts notice on behalf of the, appears on behalf of Mr. J.C. Lanunsang, and counsel for the MPSC, standing counsel for the MPSC, and accepts notice. Okay, accepts notice. List the matter. Accordingly, let the matter be listed again after a week
22nd, my lord.
on 22nd. 22nd.
Thursday.
The opposite parties may file their objection in the meantime, so advised. Then go back to the main writ petition. Oh, where are you going to? The writ petition. What is the last part of the order? Okay. Miss Daphne Lalswai.
Leshwaitlongi, my lord.
Ms. Daphne Lalwaitlongi, learned counsel, appears on behalf of Mr. J.C. Lanunsang, learned standing counsel, MPSC, and submits that they have already filed their counter affidavit. Objection or counter affidavit? I think counter affidavit.
Yes, my
Counter affidavit to the writ petition. Stop. Okay, then you write that. Okay, list the matter. No, what did I say? What was the last line? Praise aloud. Objection, na? Miss Mary had sought for 2 weeks' time. What did I say? Okay, then you repeat that, Miss Daphne, okay? After that, that'll do. Okay. IA will be taken up on that date.
Yes, my lord.
Meanwhile, you can file your counter, state. So what remains now?
My lord, in regard, if I may make one submission in with regard to the 2 weeks time, my lord. It was stated that during the month of May, some of the incumbents will get their retirement. So if a term may be met by the state to submit their affidavit within a week's time, my lord.
Yes, Your Lordship, I'll see what I can do. If matter be listed on 22nd, I'll see what I can do.
My lord. My lord.
Any second, okay?
My lord.
Item 10.
My lord, this is regarding the contract. As per my prayer, I have prayed for setting aside and quashing along with staying of the my lord, this has become infructuous as the respondent state has revocated the termination contract, my lord. My termination contract was revocated by the state government, by the state respondents.
So can it be disposed as
Yes, my
infructuous?
lord, and the money has also been deposited into my account as well.
Please write. Miss Valentina Laldinpui, Learned Counsel for the petitioner, submits that the state respondents have revoked the termination of the contract of the petitioner. And that the bank guarantee which was encashed is being deposited in the bank account of the petitioner. So such being the development, she submits that the writ petition has become infructuous. Stop. Who has produced this? You or
State,
he?
my lord.
I have.
Ms. Mary L. Kiangte, learned government advocate, agrees to the submission and also submits and also produces the communication dated 25/11/2024. The contents of which is as per the submission made by Ms. Valentina Laldinpui. Stop. In view of above, the writ petition stands disposed of as infructuous. The communication dated 25/11/2024 is being retained in the record and marked as text for identification.
Item 11.
My lord, I'm for the respondent, and we are yet to file a affidavit in opposition, my lord. And we'll be filing within this week.
You are for the,
A respondent.
which respondent? University.
Yeah, university.
When will you file?
My lord, we will be filing it within this week.
Okay. Will it list it again after a week then?
Yes, my lord.
Ms. Ruth Dalrot-Felly, learned counsel appearing for the Mizoram University, submits that she'll be filing the counter affidavit within the course of this week. Stop. Mr. Lalbi Agnuwal of Namte, learned counsel for the petitioner, is present. In view of above, list this matter again after a week.
Obliged, my lord.
Hearing item 14.
May I please, Your Lordship? My Lord, the instant writ petition has been filed. My Lord, yes, my Lord. This can, my Lord, the petitioner was elected as a member of MDC in the Tsangma Autonomous District Council. And as per, there is a rule, 2003 rules, saying that a member of a CIDC can avail loan. Advance of rupees 3 lakhs for housing loan as well as for payment of car loan. and that rule has been amended in the 2023, and the amount has been extended to rupees 10 lakhs. That the instant petitioner has filed an application. However, my lord, that has been his application for the loan has been rejected, and he has not been given any reply till date. My lord,
For rejection?
my lord,
Or they don't like you. That's why they're not giving you.
my lord, the respondents had filed a reply in which the main case is that loans cannot be sanctioned at this stage by the CIDC due to lack of funds, and sanctioning of loans will be made on receipt of revised estimate from the state government.
We'll do one thing. We'll come back. Let's take a break.
My lord.
We're just over time.
My lord,
Perhaps we'll come back at 2:30
my lord.
since we're rising late.
My lord, yes, the reason for not granting the loan is the financial constraint. That is the main reason.
All right.
And my lord, the petitioner is now in the ruling party. He is the advisor to the CEM right now.
See, what I said, we can come back at 2:30 and take a call.
My lord,
If you say you're not ready, we'll adjourn it.
my lord, can it be taken up on Thursday? Because
Why?
the respondent number one, I have the instruction that the respondent number one is to talk with the petitioner.
Regarding what?
Right now.
Regarding what? For settlement?
Yes, for settlement. As to whether he can make some consideration for his.
What do you say? Thursday?
My lord, my lord.
Okay, as paid for by Mr. As paid for by the parties list the matter again on Thursday.
Right, Your Lord.
Any more?